Hello everyone, welcome to yet another session for current affairs of the daily news analysis by SRIRAM'S IAS, where we take up the important articles featuring in the Hindu newspaper and break them down for our understanding. Let's start the discussion today with the important articles of the day. The important articles which feature in the Delhi edition of the Hindu newspaper are on our screens. Let's take up the first article. The first article which appears on the screen reads, how Turkey made peace with Sweden and Finland joining NATO. Now, as many of you must be aware, this was a major development of negotiations going on, wherein the up until neutral countries of European region, Sweden and Finland, were now keen to join NATO, but they were opposed from a already NATO member of Turkey, wherein they had certain reservations about these two countries, and that is why Turkey was against Sweden and Finland joining the NATO. So, in this backdrop, we'll understand what this issue is about. Why do Sweden and Finland, up until now, who were neutral countries, want to join NATO? Why was Turkey against them joining into this group? What is the NATO or the North Atlantic Treaty Organization all about? We'll take a look at this information, and this becomes important from us from the international relations point of view, both from the perspective of prelims and means. So, let's take a look at, first of all, what this NATO is. First of all, what is NATO or the North Atlantic Treaty Organization? It is a military alliance established by the North Atlantic Treaty, also called the Washington Treaty, which was signed in April 1949 by the United States primarily. So, this is an organization primarily based for military alliance, headed by or first initiated by USA along with Canada and several Western European nations to provide collective security against the Soviet Union, which was then existing. Now, the Soviet Union has disintegrated into many countries. So, in order to protect themselves from Soviet Union, the US and other countries prepared a military organization which they named NATO. Now, why has this NATO come into the picture again? We know that there is a Russia-Ukraine war going on, wherein Russia has tried to invade into various parts of Ukraine. And why has Russia done this? One of the reasons which Russia has given to carry this invasion out is that Ukraine's willingness to join NATO, which is a direct counter adversary to Russia, and that is why Russia has given a reason to invade Ukraine. In this backdrop, when Russia has invaded Ukraine, the other neighboring countries, which are Sweden and Finland, will also feel insecure, will also feel unsafe with respect to the kind of situation that is going on. Hence, up until now, those countries which were neutral in the politics of Europe which was going on, now those countries such as Sweden and Finland also want to join the organization of NATO. So, let's look at who are the members of NATO right now. This is a map which shows the members of NATO. So, as we can see, the Western European region along with the USA are all part of the NATO, and these countries such as Poland, Estonia, Latvia, Lithuania, these are countries which are recently become the part of NATO organization, and now countries such as Sweden and Finland, those countries which would be here, are now wanting to become part of the NATO, and that their deal is also finalized. So, this is Russia, and this is Ukraine. Up above Romania, this is Ukraine, right, and this is Russia. So, this is the context of Sweden and Finland wanting to join NATO. Now, what is the reason now for Turkey to oppose their joining the NATO? So, what happened is that Turkey feels that there are a certain separatist group existing in Turkey which are known as the Kurdish militants. It feels that Sweden and Finland house these Kurdish separatist terrorist groups, and therefore it was against Sweden and Finland joining the NATO group, because it felt that Sweden and Finland have interests which do not align with that of Turkey, and Turkey, already being a member of NATO, had the veto power to not allow a new member to join unless and until every other member of the NATO or North Atlantic Treaty Organization is agreeing to join, agreeing the other nation to join the treaty. And what reservations did they have? They felt that the Kurdish separatist group which exists in Turkey were being housed by the countries of Sweden and Finland. So now what happened, that now Turkey has agreed for Sweden and Finland to come on board and let Sweden and Finland join NATO. So finally Sweden and Finland and Turkey have signed a tripartite agreement which is called a Memorandum of Understanding amongst these three of them, agreeing on certain terms, and these terms are based on Turkey's reservations which the countries of Sweden and Finland are wanting to satisfy. So they have agreed to change their counter-terrorism laws of their country to suit Turkey's wishes. Secondly, they have agreed to extradite all the suspects and criminals which Turkey feels are being harbored in these two countries. And third is the removing the arms embargo. Earlier, Sweden and Finland had disagreed from sending arms to Turkey or selling arms to Turkey, and in this agreement now this arms embargo or prohibition on selling the arms has been removed. So these three things have been achieved by Turkey in the form of an agreement with these two states, and by that, fulfilling its wishes, it has agreed to these two countries now joining the NATO. What will happen after these two countries have joined the NATO organization now? It will certainly increase the footprint of this organization, which is against the country of Russia at this moment. So it would increase the footprint in the European region, and also make these other countries, European countries, who somewhere fear the possibility of a military engagement with Russia, will feel much safer with this organization. But do the chances of conflict increase or decrease with this development? That remains to be seen in the time to come. So this was the backdrop with respect to Sweden and Finland joining the NATO organization, and Turkey, which was earlier opposing them, now agreeing to let them join. With this, let's move on to our next article for the day. The next article which appears on the screen reads Vice Presidential Poll on August 6. This is a election commission announcing the date for the elections of the Vice President of India. The current Vice President of India, who is Mr. Venkaiah Naidu, would be finishing his term, and the Constitution of India says that before the Vice President, incumbent Vice President, finishes his or her term, fresh elections to substitute the position has to be done before the finishing of the term. So hence, elections are going to happen on August 6 before the incumbent Vice President finishes his term. This becomes important for us to study from the GS2 point of view with respect to various constitutional positions. So we'll take a look at the election process of the Vice President and other important aspects of the appointment of Vice President. So let's take a look. When we talk about the Office of Vice President of India, the article pertaining to the provisions for Vice President is contained in Article 63 of the Indian Constitution, which wherein we get different provisions for the Vice President as to what should be the qualifications for the Vice President, what should be the terms of service, conditions of service, as well as what are going to be the powers and functions, how the removal would be, how the election would be carried out. All of these conditions are mentioned from Article 63 onwards. So the Office of Indian Vice President is modeled on the lines of American Vice President. It is similar to some parts of as to the procedure of American Vice President, but it is not exactly similar. How it is not exactly similar, we'll see to that. The second highest constitutional office in India, which is the post of Vice President, rank only next to the office of President of India in order of precedence. So as we know, the President of India is known as the first citizen of India, and that is how the second highest constitutional office belongs to that of the Vice President's position. And he or she is also the ex officio chairperson of Rajya Sabha, which is mentioned in Article 64. So he heads, ex officio means that by virtue of the person taking the position of vice president, he or she becomes the ex officio chairperson of Rajya Sabha, which is the Council of States. And the vice president is a member of neither Lok Sabha nor Rajya Sabha. He is not considered to be a member of either of the two houses. And the original constitution provided that the vice president would be elected by the two houses of parliament assembled at a joint meeting. But this cumbersome procedure was done away by the 11th Constitutional Amendment Act of 1961. So how does the election procedure take place now? The election of vice president takes place in an indirect manner, much similar to how the presidential election takes place. What does indirect election means? The citizens of the country do not directly go and vote for their candidate as we do for the Lok Sabha elections or the general elections, but this election is done in an indirect manner wherein those candidates which the citizens of India have elected in the form of MLAs and MPs, that is the member of state legislative assemblies and the member of parliament, they form an electoral college or a group of voters in this election, and they constitute the electoral college to vote for the election of vice president. That is known as the concept of indirect elections. So indirect elections with the system of proportional representation, which means that each person have a single vote by means of a single transferable vote, and the voting are by secret ballot, wherein each person who they want to vote for is kept secret and their vote is also secret. So this is the concept of indirect election for electing the office of vice president. And when we say the electoral college, which means that who all are going to be the voters in the election, so the electoral college consists both elected and nominated members from Lok Sabha and Rajya Sabha only. So which means that only the members of parliament, not the members of state legislative assemblies which belong in the states, only the members of parliaments from there both elected and nominated members would be the members consisting the electoral college, which means that these would be the people who would be voting for the office of President of India. How is this different from the presidential elections? We have seen that in the election of president, the nominated members do not vote because these members are appointed by the president himself or herself, and other than the members of parliament, the members of state legislative assembly also take place. So that is the difference between the electoral colleges for the election of president and vice president. Then in the election of vice president, it does not include the members of state legislative assemblies. We've seen this, and consists of both elected and nominated members of the parliament only. This we saw. So this is the special point with respect to election of vice president, which also differs in some ways with respect to the election of president of India. Alright, after election now, what are the qualifications for which a person has to have to stand for the office of vice president of India? So first is that he or she should be a citizen of India. Then they should have completed 35 years of age, and then they should be qualified for election as a member of Rajya Sabha. So as we saw, they are not deemed to be a member of Lok Sabha or Rajya Sabha, but they should be qualified for being a member of Rajya Sabha, and they should not hold any office of profit under the union government or any state government or any local authority or any other public authority. So this is an important point wherein in order to stand for the election of vice president, that person should not hold any office of profit, which means that any position which is a position of taking money and is under the union government, state government or any other body affiliated to the government, which might bring a conflict of interest later on. So that is not permitted, and he should not hold any such office. And fourth is the nomination of a candidate for election to the office of vice president must be subscribed by at least 20 electors, that is members of the parliament as proposers and 20 electors as seconders. 50 proposers and seconders in case of president. What does this mean? This means this is a requirement kept to check that not anybody can come up to stand for the election and he or she at least has some backing. So whenever a person is to stand for the election of vice president, his nomination should be subscribed by at least 20 members of the parliament, that 20 members are supporting him in his nomination. This number is 50 in case of president. So this is the requirement which has been kept to check for the legitimate standing of anyone who stands for the election of vice president of India. Then after qualifications, what are the conditions of office? The conditions of office say that he should not be a member of either house of the parliament or house of the state legislature while assuming the office of vice president. And then if any such person is elected vice president, he is deemed to have vacated his seat in that house on the date on which he enters upon his office as vice president. So even if he or she is a member of any such legislative office, be that of the state legislature or parliament, that office would be deemed to have vacated once he or she assumes the position of vice president. And then he should not hold any other office of profit. This we saw was a condition of holding the office of vice president. Then we come to terms of office. Once being appointed to the office of vice president, what are the terms? The vice president holds office for a term of 5 years from the date on which he enters his office. So the term for the vice president stands for 5 years, and he can resign from his position at any time by addressing the resignation letter to the president. So he submits the resignation letter to the president, and the vice president can hold office beyond his term for 5 years until his successor assumes charge. So for example, let's say the August 6th date that has been designated for the election, if due to some reason the election does not take place or gets delayed due to some reason, in that case the office would not be left vacated just because the term of the vice president has gotten over. That vice president will continue to hold the term, continue to hold the office unless a fresh election has taken place and the office is now substituted with a fresh candidate. So that is the term of office, and he is also eligible for re-election to that office for any number of terms. So the sitting vice president can also stand for the election again. After this, let's take a look at the powers and functions of the vice president. So the vice president, in the virtue of his office after the president, is the highest dignitary of India after the president, and certain powers are attached to the office, which are that we saw this, that he acts as the ex officio chairman of the Council of States. In this capacity, his powers and functions are similar to those of the Speaker of Lok Sabha. When he becomes the presiding officer of the Rajya Sabha or Council of States, he is effectively the Speaker of that house, so he wields the same power. So apart from being the vice president, he also acts as the presiding officer or chairman of the Rajya Sabha, and then he acts as the president when a vacancy occurs in the office of president due to his resignation, impeachment, death or otherwise. So if due to any reason the office of president falls vacant, the place is taken by the vice president, where he is the acting president. Here is where the position of Indian vice president differs from the American vice president, from which this position is largely inspired from, wherein in the case of US vice president, if the office of president falls vacant, the vice president takes the charge of the president. But in the case of India, that does not happen, and the vice president is only the acting president, and a fresh election for or fresh appointment of the president shall soon take place. So that is the differentiating point between the Indian and American counterparts. And then he can act as the president only for a maximum period of 6 months within which a new president has to be elected. So he is the acting president for 6 months, a maximum period of 6 months within which the elections of the president should take place. Further, when the sitting president is unable to discharge his functions due to absence, illness or any other cause, the vice president discharges his function until the president resumes his office. So even for a cause of illness or anything, the vice president can assume the office until that point of time. So this was the discussion with respect to the vice president as to how exactly the election takes place, what are the conditions of office, and what are the various powers and functions that this office holder assumes and holds. So with respect to this, let's move on to the next article for the day. The next article which appears on the screen reads, do not give green nod for Mekedatu project. Now the Mekedatu project, which is a reservoir project, has been in news for quite a few time now, and it is a project which is being carried out on the river Kaveri in the state of Karnataka. So the river Kaveri origins in Karnataka and flows from Karnataka to Tamil Nadu to finally drain into the Bay of Bengal, and that is why whatever action or whatever construction of dam that would take place in one state, especially the upper riparian state. The upper riparian state is known as, when the river is flowing, the upper part where it flows, the region is known as the upper riparian region. So in this case, the upper riparian region would mean the Karnataka region and the lower riparian region would mean the Tamil Nadu region. So that is why whatever negotiations are going on with respect to the Mekedatu project, which stands in the region of Karnataka, there exists a lot of conflict points between these two states, wherein the Tamil Nadu does not want this reservoir project to be carried out in its present form, because it feels that this reservoir might affect the water needs of the people of Tamil Nadu. That is why the current article is saying that the Ministry of Environment, Forest and Climate Change should not give the environment clearance to this project. So now we'll understand about the Mekedatu project and about the river Kaveri and about the issue which is and other points which are surrounding this issue. So about the Mekedatu project, first of all, it is a 9,000 crore project, which is a dam project to store and supply water for drinking purposes for the Bengaluru city. So the water that would be stored from this reservoir would be supplied for the Bengaluru city residents, and around 400 megawatts of power is also proposed to be generated through this project. So again, Mekedatu project, which is on the Kaveri river, and the approval from MOEFCC is crucial because 63% of the forest area of the Kaveri Wildlife Sanctuary would be submerged, and that is why there are concerns, and therefore clearance from the Environment Ministry is very crucial. Now understanding few things about river Kaveri, it is also known as Ponni in Tamil and known as Ganga of the south, and it is the fourth largest river of southern India. It flows from, this is the river Kaveri, which has its origin in Karnataka, then finally flows from Tamil Nadu to drain into the Bay of Bengal. So it rises in the Brahmagiri hills of the Western Ghats in southwestern Karnataka states, flows in a southeasterly direction through the states of Karnataka and Tamil Nadu, and descends the Eastern Ghats in a series of great falls, finally draining into the Bay of Bengal through Pondicherry. And some of its tributaries are the Arkavati, Hemavati, Lakshmana, Tirtha, Shimsa, Kabini and Harangi. These are some of the tributaries of the river Kaveri, and the Mekedatu project stands at the Karnataka and Tamil Nadu border, nearly at the border. That is why there are certain conflict points between these two states. So this was the discussion with respect to the Mekedatu river project, wherein the important point for us to understand was where exactly is the Mekedatu project river project situated, on which river, some important points about the river, and what are all the points surrounding this project. So with this, let's move on to our next article for the day. The next article which appears on the screen reads, KK Venugopal to remain AG for 3 more months. AG, which also means Attorney General. So therefore, the incumbent Attorney General, his term has been extended for 3 more months. In this context, we will understand about the very crucial constitutional office of the Attorney General, which becomes important for us to study from the GS2 point of view. Right? So let's look at the office of Attorney General of India, who is a part of the Union Executive. So who is the Attorney General? He is the highest law officer in the country, which means that the government, the Union government, appoints a person as its principal law officer to deal with all kinds of cases that the union government might enter into and other such legal implications that the union government might have to occur. So for that, the top law officer which the union government appoints is known as the Attorney General of India, right? And Article 76 of the Constitution provides for the Office of Attorney General of India, where it enumerates certain provisions for the eligibility, appointment, term and other powers and functions of the Attorney General. So what are these things? First of all, let's look at the appointment and eligibility. Who appoints Attorney General? He is appointed by the President on the advice of the government. It means that he is appointed by the seal of the President, but who should be appointed has to be on the advice of the Council of Ministers of the government, and he or she must be a person who is qualified to be appointed a judge of the Supreme Court. So he must be similar to those qualifications as are required to be appointed a Supreme Court judge. That is, he or she must be a citizen of India and must have been a judge of some high court for 5 years or an advocate of some high court for 10 years. So he can either be a judge of high court for 5 years or a advocate of some high court for 10 years or an eminent jurist in the opinion of the President. This line, that an eminent jurist in the opinion of the President, leaves grounds open for the President to judge according to his discretion, effectively which is the government's discretion, to choose any suitable person for the office of Attorney General. And what is the term of the office for the Attorney General? It is not fixed by the Constitution. Here is where the term has been extended as mentioned in the article, that since the term is not fixed by the Constitution, any number of months or years can be granted to the Attorney General's appointment. That is why the incumbent Attorney General's term has been increased for 3 more years. And the removal process for Attorney General, procedures and grounds for the removal of Attorney General are not stated in the Constitution, which means that he or she will hold the position at the discretion of the President. When the President wants to elect, he can elect a Attorney General, and when he wants to remove, he can be removed. So he holds office during the pleasure of the President and may be removed by the President at any time. This is the removal procedure for the Attorney General. Then we come to the duties and functions of the Attorney General. So what are the duties and functions that the Attorney General has to do? So first function that the Attorney General has is to give advice to the Government of India upon such legal matters which are referred to him or her by the President. So he is there as a legal advisor for the government, based to call upon various policies, various decisions of the government. He will be advising on the legal implications, and to perform such other duties of a legal character that are assigned to him or her by the President, which means that any case which the Union of India or the government is involved in, Attorney General would be the person to fight that case, which is the reason why we often see that in a case where the government is involved, the Attorney General is making the arguments in front of the court. Then to appear on behalf of the Government of India in all cases in the Supreme Court or in any case in any High Court in which the government is concerned, which we just saw. And then to represent the government in any reference made by the President to the Supreme Court under Article 143, which is the power of the President to consult the Supreme Court, which is the advisory jurisdiction of the Supreme Court of the Constitution. So in this case, he can also represent the government in such matters and to discharge the functions conferred to him or her by the Constitution or any other law. So the ambit for the Attorney General is quite open, and he or she has to perform those functions which are legal in character and have legal implications for the government. Apart from this, the powers and rights that the Attorney General have is that he has the right to speak and to take part in the proceedings of both houses of Parliament. So as we know, those who have the right to take part in the proceedings of Parliament are generally elected members, those known as the Member of Parliament, but Attorney General has the special right to participate in the proceedings of both houses and to speak in those proceedings or their joint sitting and any other committee of the Parliament as well, of which he or she may be named a member but without a right to vote. So this becomes the differentiating factor from the members of Parliament, wherein he or she is allowed to take part in the proceedings and speak on the matters as well, even take part as a member of committee, but not have a right to vote in the proceeding. That belongs solely to the member of parliament, and he or she enjoys all the privileges and immunities that are available to a member of parliament. So all the immunities and privileges available to the MPs are also available to the Attorney General, and he or she does not fall in the category of government servants. He or she is not debarred from private legal practice, which means that the concept of office of profit is not applicable over here, wherein the Attorney General, apart from working for the government as the top legal officer, can also simultaneously carry out the private legal practices of his or her own if they want to. So that is the liberty that is going to given to the Attorney General. However, he or she should not advise or hold a brief against the government of India. So here the office of profit principle applies, wherein any brief which is against the government of India, that would be accepted, and that would form a limitation on the power or privilege of the Attorney General. And the Solicitor General of India and the Additional Solicitor General of India, these are two posts which are also mentioned in the Constitution, who are subordinate to the Attorney General. So they assist the Attorney General in the fulfillment of the official responsibilities. So they are the people who are subordinate to Attorney General. And who is the top law officer counterparts in the states? They are known as the Advocate General, with the provisions of which are mentioned in Article 165 of the Constitution. So Advocate General are the top law officers of the state, wherein they perform the same functions which the Attorney General is doing, but for the state executive, right? So this was the discussion on today's important articles. We'll meet again tomorrow with the important articles for the day. Thank you very much.